We're on to our fourth panel that addresses the topic of court support for arbitration in its three stages: before, during, and post-rendering of the arbitral award. To moderate the discussion, we have the Honorable Dr. Justice Arjan Kumar Sikri, Judge of the Supreme Court of India. When he joined the bar almost 40 years ago, Justice Sikri specialized in constitutional, labor, service, and arbitration. He was counsel for numerous public sector undertakings, educational institutions, banks, etc., and also taught part-time at the law faculty. Our panelists are the Honorable Dr. Justice D.Y. Chandrachud, Judge of the Supreme Court, formerly was the Chief Justice of the Allahabad High Court and a former Judge of the Bombay High Court. Some of Justice Chandrachud's prominent judgments are in the area of constitutional law and the protection of human rights. He has also authored several articles on human rights. Honorable Mr. Justice R.V. Ravindran, former Judge of the Supreme Court and also former Chief Justice of the Madhya Pradesh High Court. Justice Ravindran has rendered landmark judgments on issues of the Constitution, reservation, education, and human rights. Mr. Janak Dwarkadas, Senior Advocate of the Supreme Court, widely known for his balanced approach to legal challenges, and he also commands enormous respect in the legal fraternity. Ms. Sharina Petit, a partner and head of the India practice at Norton Rose Fulbright in London. She also coordinates Norton Rose Fulbright's Asia, Europe, and the Middle East arbitration practice and sits on the board of directors of the LCIA, SIAC Users Council's United Kingdom National Committee and is part of the ICC India Arbitration Group. Ms. Petit specializes in international arbitration, ADR, and regulatory investigations. We also have Mr. Arvind Dattar, Senior Advocate of the Madras High Court, a qualified cost and works accountant. He practices at the Supreme Court, the Madras, and other high courts, and has specialized in taxation, company, and constitutional law. I now hand you over to the Honorable Dr. Justice Arjan Kumar Sikri.
Thank you, and good afternoon to all of you. I suppose that you had a hearty lunch, but I would request that you pay some attention to this session, which, going by the panelists, I hope that it is not only going to be interesting and lively and would keep the interest alive in you as well, but it becomes very important also from another point of view, what we have been discussing since morning. As the first session itself on how to set up world-class arbitration institution, and what was discussed there was that, look, in addition to, because it was beyond brick and mortar, but in addition to have good infrastructure, we have to have proper institutional framework, where such as institution should be managed by the persons who are not only having expertise in the field, but who are accustomed to this and know the international practices, etc. But in the process, the third thing which was discussed was the support of the judiciary. Although arbitration is a process which is beyond the court premises, it is a forum chosen by the two parties. The parties' autonomy is there, but at the same time, the arbitration by itself cannot work as well. The support of the judiciary is needed, and it is needed at all three levels, which I said, not only before the arbitration starts, during the arbitration when it is being going on, and after arbitration, which is much more important, because once the award is given by the arbitral tribunal, the enforcement of that award is the function of the judiciary. So therefore, judiciary has to play an important role. And what had been discussed thereafter in second and third session also was that the perception, what people think about the judiciary, whether judiciary is arbitration friendly, which is very, very important. And it was also said that since 2012, there are certain judgments which are progressive judgments given by the Indian courts, but still the perception in international community may not have changed. So all these, this entire discussion makes this session very, very important. 3 of us are from the judiciary, other 3 are from the profession. And together we are going to see how the image of judiciary can be changed, what steps are required in this direction, and how we should manage the work of arbitration in the courts, so that the perception which goes to the people or to the world at large is that Indian judiciary is also supportive of the arbitration process. It is arbitration friendly. Now, what I was thinking, since the scope is quite wide, as there are 3 stages, pre-arbitration, then role of the courts as facilitators, then support during the arbitration, and finally for the execution. So in the beginning, which I discussed with my panelists, and I requested, which they have agreed, that as far as pre-arbitration is concerned, I'll be asking Justice Chandrachud to throw some light. During the arbitration process, Justice Ravindran can say much, because he is now conducting the arbitration and very well sought after arbitrator, not only in India but internationally as well. So he knows both sides, like Justice Lahoti, who shared his experience. And then Mr. Datar can say, before that, Mr. Janak Das can say something about the enforcement. And Mr. Datar, I am going to give the role which I said, that when it comes to enforcement of international foreign awards is concerned. And since Sherin is here from London, so in the process, we will be asking you your London experience and how it can be imbibed, and what advantage or can be taken, or benefits which can be taken by us while dealing with this. So my first question to Dr. Chandrachud, that when it comes to pre-arbitration, there are, apart from section 5, which says that normally when the arbitration is going on, judiciary is not to interfere with the arbitration process. That is the fundamental principle or message behind section 5. But apart from that, section 8 and section 11, because as we have been discussing, of course, if we have the institutional arbitration, that may take care of much of the malaise. But as of today, we have ad hoc arbitration also in large measure. Applications come before the courts under section 11, and court has to appoint the arbitrator. We normally go for ad hoc arbitration. What was discussed since morning, and from there, if I may tell to you, that why not, and it was the voice of many, why not in section 11, the courts can refer the matter to institution instead of appointing an arbitrator. And Justice Lahoti again made a very significant point, which was this, that his experience shows that many judges, while appointing arbitrators, they don't look into the complexities involved in that particular case, and keeping in view those complexities, who should be the arbitrator appointed, maybe a judicial member, maybe a non-judicial person, and sometimes a particular judge is giving preference to one particular person and making. So how these things can be taken care of, and in the process, if you can throw light on this also, that many times when section 11 application comes, and say there is a challenge to the arbitration agreement itself, that it is null and void or illegal, etc. Now, in some jurisdiction, the most of the jurisdiction, I'll say, I've seen in England, Shirin will say much on that, but in Singapore also others, that we'll only look into the prima facie aspect. And if once it is proved that yes, prima facie, there is a validity of the agreement, we are not going to go further. But then in India, it was in Shetsu 1 in 2005, the court said yes, prima facie, but in 2013 it said no, we should finally decide about this aspect. So how you think that the time can be curtailed at this stage so that the process starts as early as possible, and what should be the judicial approach?
Thanks, Justice Sikri. Well, this is an area where courts and arbitrators, or courts and arbitral tribunals, they are not antagonistic. I think this is one area where first and foremost we have to realize and understand that we are partners. We are partners in a process of facilitating arbitration. Because otherwise the dominant theme really has been that court support for arbitration is really equivalent to court non-intervention in arbitration. That may or may not be so, and support and intervention are not necessarily antagonistic. Support for intervention, support for arbitration does postulate, particularly at the pre-arbitration stage, which I'm going to deal with, the fact that the court has to proactively assist in the efficacy of the arbitral process. Now, briefly stated, as we know, there are 4 or 5 areas where the court can intervene to facilitate the efficacy of the process. First, by the mandate that it is obligatory, it's non-negotiable, that you have to refer parties to arbitration where prima facie an arbitration agreement exists. Second, the court is bound to intervene and grant timely measures, interim measures, where one of the parties has approached the court for the grant of an interim measure of protection. Unfortunately, we haven't still embodied, as part of our institutional arbitration, requirements of emergency arbitrators. So that casts a very added responsibility on the court to ensure that in the absence of any provision for emergency arbitrators, that the court must intervene and intervene effectively right at the outset when an interim measure of arbitration is sought. The third is when the court considers an application under section 11. The fourth, and that is when the court really disposes of an application for the appointment of an arbitrator. The fourth is in designating expert institutions, institutional arbitration, to facilitate and enhance the process of institutional arbitration. Now, I see no reason why, in the course of a proceeding under section 11, why the court should not really entrust that task to an institutional body to facilitate the process of arbitration. And the fifth area, which is really the soft area, and that's not really something which is specifically provided for in the Act, that is an area of the courts managing arbitration litigation in such a way that you make that effective within your institutions, for instance, by constituting specialized benches, or for instance, by ensuring that arbitration applications are not just part of your overall volume of litigation, which the court is encountering from day to day, be it your civil litigation or your criminal litigation, that you earmark certain specialized benches, either as part of the commercial benches which a large number of high courts do have, or even otherwise, even apart from that. Now, just a couple of issues which I want to flag and which are of some significance. First, whom does the court appoint? The Act doesn't tell us who the judge has to appoint as an arbitrator. And the real problem which you face is the excessive emphasis, if I may say so, and it's tough coming from a judge to say that, but I must say that nevertheless, that we have a tendency to appoint judges as arbitrators. Now, an alternate experience or an alternate model is capable of being efficaciously implemented, and which is really to broaden the base of arbitration, because the number of arbitrators whom we have in India today is far short of the issues which judges can deal with. Judges are doing excellent work, former judges are doing excellent work as arbitrators, but you also need to broaden the area of arbitration, the base of arbitration, to cover not the highest value or high value commercial disputes, but a large number of medium value commercial disputes. And why don't we then look at the commercial bar being really roped in and being utilized, particularly mid-level juniors, to facilitate the process of arbitration. This is an experiment, for instance, which we employed in Mumbai when I was a judge of the Bombay High Court. even matters which were otherwise not capable of being resolved in arbitration, such as petitions for winding up, which classically are outside the fold of arbitration. These are essentially small commercial disputes between contesting parties. And if we facilitate the process of arbitration by appointing members of the bar who are specialized in that branch of commercial law, be it admiralty law, or maybe be it basic commercial law or securities law, there could be a great scope there to further the process. Second, insofar as specialization is concerned, it's equally important to develop an arbitration bar, a specialized arbitration bar in India. And I think one of the great constraints in India has been that the arbitration bar is pretty much the same as the civil bar or the commercial bar in any court. I think that disconnect has to take place, so that just as more and more people are becoming expert specialized arbitrators, so also you must have a specialized arbitration bar from whom you will be able to generate a number of arbitrators. When do you refer matters to arbitration? 8 uses the expression prima facie. Now, for a long time we were caught up in this great debate on whether fraud is a ground not to refer parties to arbitration. And there was a judgment of our court which said that if the allegations that are made involve an element of criminal wrongdoing, that cannot be arbitrated upon. Fraud is something which cannot be arbitrated upon. In a recent judgment, Justice Sikri led the bench. We tried to make a slightly different path. We have struck a different note in that judgment to this point that is there something intrinsically about fraud that makes it inapposite for a court to entertain a dispute? Generations of our judges have dealt with fraud in the context of civil trials. Now, what is it about fraud that cannot go to arbitration? So therefore, if we have to give a sense of business efficacy to arbitration agreements, then fraud surely cannot be an issue which lies outside the pale of arbitration. Second, as our Act now recognizes the doctrine of separability, or the doctrine of the severability of the arbitration clause, so that even if the underlying contract is vitiated, either by reason of fraud or bribery or corruption or undue influence, the arbitration agreement survives despite the collapse or the invalidity of the main agreement. Once the doctrine of severability is established as a well-established part of our law, then fraud really doesn't present us any difficulty at all. Notwithstanding the element of fraud in the execution of a contract or in the performance of the contract, there is no reason why the dispute cannot be held to be arbitrable. Now, the fraud really is a major issue which has bedeviled arbitration, and hopefully that controversy has been set at rest with the 2000 amendment and the recent judgment of a court. Last point which I really want to make is that this 8 says that you treat the issue of whether there is the existence of an arbitration agreement as a prima facie determination. To my mind, there's a need for a rethink as to whether we should or should not follow the same principle when you deal with a Section 11 matter. Because if you otherwise require a judge at the stage of Section 11 to decide conclusively as to the existence of an arbitration agreement, that is an open invitation really to delay the entire process of arbitration. So even at the 11th stage, there's a great amount of weight in the view that the court should do no more than apply its mind prima facie about the existence of an arbitration agreement. But really the bottom line, the last thing that I want to say is that this is an area where the proactive intervention of the courts is necessary, because arbitration can equally be delayed, it can be defeated. It can be defeated by parties who take recourse to all kinds of ruses. And there you have the remedy of a court, an institution which says that we support arbitration. And if you have a court, if you have an institution which supports arbitration, I think that goes a long way in pursuing the process.
Thank you, Justice Chandrachud. You made a very good point about specialized benches and specialized arbitration bar. As far as specialized benches is concerned, at judiciary level, it can be taken care of. The Chief Justice of a particular High Court or Chief Justice of India can think, yes, I make a bench. How would you like to throw some light on this comment, that how we can create specialized arbitration bar? Because that is up to the lawyers. We can't tell them that you practice only in one subject and don't practice in another subject.
Well, two things. One is about the specialized bar, and about another is about the specialized judges. There have been some talk of sensitizing the judiciary about the need for fast-tracking arbitration matters. I have my own reservations. In regard to high courts where you may have a commercial bench, or in regard to district courts where there is a designated commercial bench, it may work well. But where there is no designated commercial bench, do you ask a judge who has a poor farmer's case and a poor laborer's case and an arbitration case that you give preference to arbitration? Do you try to tell him that? It will lead to very serious consequences that would, it would be seen as if the courts are for the rich. The better course would be to have designated commercial courts, specialized courts. Insofar as Delhi is concerned, for example, it is not a problem at all. It is not a problem because the jurisdiction is with the High Court and you have a commercial kind of, already a bench is there which is well versed in arbitration matters. But in other states where the matters go before the civil judges senior division, who may not know anything about the commercial law aspects and arbitration matters, it is very, very difficult. As far as the bar is concerned, there is an absolute we have to get rid of this, evening tea arbitrations, 5 to 7, which is specially prevalent in Delhi. But in most of the other places, I would say, for example, Bombay, you don't have that system. There is a committed arbitration bar. But with 29A coming in, I am sure even in Delhi, a professional commercial arbitration bar will develop.
So if I take it that it depends on arbitrators also. If arbitrators say that no, I want to hold hearing from 10 to 5 and it's not that it is only after 4 o'clock or it is not only on Saturdays or Sunday, then it will necessarily lead to have. Sharina, can you say that what is your experience in UK or in Western countries, how they could have this arbitration advocate specializing in this field, how this sector emerged?
Yeah, in terms of an arbitration bar, at least in London, there is quite an arbitration bar. So there are different sets, and so if there's a construction dispute, you would normally go to a construction set. And sometimes you'll have all 3 members of your tribunal from the same set. Sometimes you'll have all 3 members of your tribunal from the same set, as well as counsel as well from the same set. So these are specialized bars. One other thing that the institutions have started doing is keeping a blacklist of arbitrators. Now this sometimes used to be kept informally, but I believe that now they're not going to keep this informally. That itself is going to be a deterrent for people to take up arbitration. So for example, last week I was asked to sit as a chair for a shipping arbitration. And I declined that because I don't have shipping expertise. And I'm not going to claim to have it. And I don't want to be on a blacklist. So I think that is a big deterrent that prevents people from trying to overstretch their capabilities.
Okay. Now coming back to your this on fraud, what you said, and recent judgment which was of course given by both of us, and let me acknowledge here, I wrote the main judgment but supplemented by him, which is much better in quality than my judgment. And but in the morning, one question was asked to Mr. Bull, who was from Singapore. He said that in Singapore also we distinguish between civil fraud and criminal fraud. If it is a totally criminal matter, then naturally it is out. But it is have its civil trappings, then it is arbitrable. So almost same thing which we have done. Of course, sir, your judgment which was there earlier, where you had, which was that case, Booz Allen. So we have tried to explain that, and I hope that this may curtail to some extent, because it is a tendency to challenge every arbitration agreement on the ground that fraud is there, and it is, as very rightly pointed out by you, that fraud can be one element. And another point which can be well taken off, and but it has to be by the benches when Section 11 application is taken care of, that cases which don't involve large amounts and medium scale cases, and the lawyers also of that category, it will not only may have speedy disposal because they may not be having much work, but cost effective as well. I think that is a point well taken. So, Justice Ravindran, I come to and ask you the question now about, as well as during arbitration proceedings, assistance of the court. The main provisions are section 15, 17, 27, 29 and 37, etc. But the what I want to ask is that on the one hand, if we see the scheme of the Arbitration Act, it is a self-sufficient system. Whether support of the court at all is required, particularly while taking the evidence. And another question which I'll ask you is that many times under section 17, orders are passed by the tribunal which are interim measure, and there is no mechanism of enforcement of those orders. Appeal can be filed, that's a different thing, but should there be a power given to the court to support those orders, that power of contempt, that if the party is not obeying or it violates the interim measure, then contempt jurisdiction can be used?
First about Self-Sufficient Arbitration Act not requiring the support of courts. At present, the support of the court is required only under 14.2, 15.2 and 17.2. See, where, let us say, arbitrator is not continuing, somebody has to be appointed, yes, or some witness is not coming, witness summons has to be issued, 27. These are all the matters they are actually supporting. They are not interfering with the arbitration, they support the arbitration. As far as contempt is concerned, it is a little tricky. 27(5) is the section that is referred. The Delhi High Court has, a single judge of the Delhi High Court has taken the view that having regard to the provisions of section 27(5), certainly the disobedience of or non-compliance with the order of the tribunal, arbitrable tribunal, is contempt and matter can be referred to court. On the other hand, the Bombay High Court has taken the view 27(5) should be read in the context of 27(1) to 4, that is where there is a disobedience by a witness failing to come, and therefore that power does not exist. Of course, the earlier Supreme Court judgments take the view that as far as arbitration is concerned, there is no contempt. But coming back to 17.2, 17.2 now says that they should be treated as deemed to be like court orders. If they are court orders under Code of Civil Procedure, maybe an application like 39(2)(a) for disobedience of an injunction, maybe something like that may be thought of. Until there is clarity, until Supreme Court pronounces upon whether 27(5) can be made use of for the purpose of contempt, initiating contempt action, I think the course is have recourse to Order 39(2)(a). That's all that can be done having regard to 17.
Mr. Datta, although I told you your jurisdiction is something else, but here I am asking you one question, another interesting question which comes to my mind at this moment. Suppose the challenge to the jurisdiction of the arbitrator is taken under section 16, competence principle, and he has to decide. Now, arguments take place, matter goes on for some time, and he dismisses, the arbitral tribunal dismisses that challenge and imposes cost also. Now, whether cost can be, that application is dismissed with cost, can be recovered at that interim stage, or it has to be only at the final stage when the award is given?
I think only at the final stage, because the 16 order ultimately goes up to the main award, and then it goes. So that will be recovered only at the final stage.
Only at the that is your answer. Yes. So that if he doesn't pay the cost, the other side asks for the cost.
It depends on the arbitrator. Suppose the arbitrator says that you have to pay the cost within 8 weeks, then that will be enforceable. Suppose he simply says dismiss with cost.
And the arbitrator also says that this cost be paid within 4 weeks or 6 weeks, and now this order is not obeyed, and that whether the contempt jurisdiction can be exercised by the court.
Well, I'm basically against contempt being exercised by anybody except courts. But now the trend is to give contempt jurisdiction to 4 other than courts also.
How Shireen, you tell us that in your English courts, how they support the arbitration process?
courts intervene very, very rarely. They will intervene if a tribunal is not fully constituted or if it lacks power. So some of the ways that it would intervene is, one is where it would need to grant an injunction, so an anti-suit injunction or a freezing award. There was a case which was AES versus JSC. JSC was a subsidiary of the government of Kazakhstan. It was under a concession agreement. The arbitration was under a concession agreement for rights to operate a power plant in Kazakhstan. Kazakhstani law was a substantive law of the contract. It was an ICC arbitration, seat London, and it was supposed that the arbitration agreement would be governed by English law. In 2004, the Kazakhstani court said that the arbitration agreement was void. So there were disputes, they went to the Kazakhstani court and it was void. AES, in 2009, there was another dispute, and again, they went to the court. The JSC proceeded in the Kazakhstani court because it wanted the value of the concession assets to be disclosed. AES said that there's an arbitration clause. The Kazakhstani court said, we've already ruled that this is void. AES in 2009 went to the English court and said, look, there is an arbitration clause in this contract. The Kazakhstani court is telling me it is void. I don't think it's void. The English court said that the arbitration clause was valid and gave an injunction restraining proceedings in Kazakhstan, and said that the English court had full jurisdiction even though arbitration hadn't even yet commenced in England. It still said, we have the jurisdiction, look at the arbitration clause.
This is the anti-suit injunction jurisdiction.
Exactly. There was another case for freezing order as well, which was prior to an award and a tribunal being constituted. It's the Econet case. The tribunal was not constituted. One of the parties wanted a freezing order. They were quite close to a tribunal being constituted. What did the court do? They said, well, it's very close to a tribunal being constituted. We will not interfere. Get the tribunal appointed ASAP. And that's what they did, because the tribunal will have the power to grant you that freezing order. So only come to the court if you actually have to do it.
Okay, so, thank you. Justice Ravindran, I want to ask you another question at this stage. Since morning, there has been a hot debate on Section 29A. Of course, Section 29A, 12 months plus 6 months is, that is between the parties. But beyond that, subsection 4 of Section 29A says that the parties can come to the court, and the court in given case can extend the time. Now, in what way, because since we are discussing about the supporting role of the courts, and that too during the arbitration, as you are speaking on, in what way under subsection 4 of Section 29A, court can play that role, and much of the or many of the apprehensions which are expressed, particularly by our friends from other countries, and 2 or 3 said, we heard that, look, we are going to advise our clients not to go to India so long as Section 29 is there. So can you assuage those feelings, and what can be the positive role which the court can play in this process?
Section 29A, much maligned section. Let us see the positive side of Section 29A. The minute 29A came, I stopped accepting fresh arbitrations because I became conscious of a time frame. So the first thing is, it has brought in some kind of discipline and accountability in arbitrators. Now, next step, the arbitrators will in turn bring in discipline and accountability to lawyers. They will say, we will not have 5 o'clock arbitrations, we will not give you adjournments, look to this because only 18 months is there, let us proceed with the arbitration, let us do some business. Now therefore, this will bring in some kind of discipline among lawyers also. And naturally, the litigants also who are accustomed to taking it easy will now ensure that the pleadings are filed in time. Therefore, let us not say it is very bad. maybe in about 2% or 3% of cases where international parties are involved or huge amounts and huge number of documents are involved, yes, it is going to be a disadvantage. But let us look at 97-98% of the cases which are routine arbitrations which can be completed within 1 year, but at present taking 4 to 5 years. The legislature has addressed that problem. Maybe you see, when you try to improve or settle one side, another side will get affected. Naturally, the international arbitration will be affected. But incidentally, because of this, if you are able to, develop discipline in India, and we can deliver within 18 months and show to the international community that we are going to deliver in 18 months, automatically the international arbitrations will come here. Because I know international arbitrations take more than 18 months. It is, well, of course, once the period pleadings and other things are there, it is quick. I know also the very same lawyers who hesitate to conduct for 3 hours or 4 hours arbitration in India, when they come to Singapore or London, I have Mr. Darius here, from 9:30 to 6 o'clock every day, continuously for 10 days, they conduct arbitrations. But you ask them to do here, they say we have got the Delhi High Court, we have got the Supreme Court, we have got this work, that work. No, that is the lack of discipline. That discipline will be brought in by 29A being enforced. So,
yes.
Courts, as you rightly said, 29A, when it comes to the court will also certainly see. It is not that in every case court is going to say no,
so
we will not.
Maybe in 1 or 2 cases, if it is tested and the court, insofar as international arbitration is concerned, going by these ground realities, liberally extend the time.
Yeah.
So that may be one message which can be, and court can help to that extent.
International
and what you say about Mr. Kambata's
international arbitrations are mostly, let us see, by statistically Delhi or Mumbai. The judges who are handling in the High Court these jurisdictions are well aware of it, and they will be able to deal with it and decide the matter immediately.
And Mr. Kambata's suggestion of amending it to exclude international arbitration.
Well, that is one way, but as he himself said, what the legislature will do or what it can be proceeded to do or something which is different. Let us hope that
I
it is
just
done.
wanted your reaction
What
on
I
that.
say is, even without amendment, it can be made to work.
Yes, Mr. Dwarka Das, you have been silent spectator up to now, but most important question which I am going to ask you is about the enforcement, the third stage we come to. And the ONGC saw pipe, the way public policy of India was interpreted by the Supreme Court judgment, and how it became a subject matter of criticism, or I would say even ridicule in the international community. And much of that is taken care of. Now, amendment is made, but my question is whether that is taken care of and it may change the mindset of the judiciary insofar as the issue of public policy is to be seen in the light of explanations 1 and 2 which are added there too, or we are going to have some problems again.
Thank you, Justice Sikri. As I understand, the purpose of this conference is to take an initiative towards supporting arbitration in India. So if I am going to talk about the judgments of the Supreme Court which have defined public policy and which have come in for criticism from time to time, I will take it that you will appreciate that this is being said as constructive criticism towards bringing about a useful change so that we do move towards a healthy enforcement environment rather than an interference mode of environment towards arbitration. So with this prefatory remark, let me also say one more thing before I answer Justice Sikri's query, and that is that way back about 145 years ago, the Privy Council had said, which is an oft-repeated quote, but I'll nevertheless quote it again, because it observed that the difficulties of a litigant in India begin when he has obtained a decree. You could say that even qua a award. Now, the reason is because, as you know, the background to the amendment made to Section 34 was, of course, the judgment which defined public policy in the context of a foreign award, which was the Renusagar judgment, where 3 grounds were laid down: contrary to fundamental policy of India, contrary to the interests of India, and contrary to justice or morality. In ONGC saw pipes, 1 more ground came to be added, which was patent illegality. Now, in associate builders versus DDA, Justice Rohington Nariman, who was of course looking at the law prior to its amendment, expounded the law, and in that sense told us what each of these 4 concepts mean, and where the challenge would lie on the ground of in conflict with public policy. And there he defined what has now become part of the statutory provision under 34(2)(b)(2) and 2(b)(3), which are the amendments which have been made, and 34(2)(a), which has been added, which is patent illegality. The problem is that when he expounded the law, which was the law then, there are a lot of subjective elements which have been introduced into the definitions. And I personally believe that it would not take very much effort on the part of any lawyer who is familiar with arbitration law to point out that these expressions which have been borrowed from the judgment in Associate Builders versus DDA of the Supreme Court must be given the meaning which Justice Nariman ascribed to them. Maybe it was under the old law, but since these phrases or expressions have already been interpreted, they must be given the same meaning.
It's a valid point, but because those expressions are elucidated and defined, so it can always be, while interpreting the 2 explanations, can always be made use of. Yes.
Correct. But the problem with that would be that a lot of subjective element comes in. Now, as you know, sir, awards are challengeable in district courts, they are challengeable in commercial courts which are set up, which may not be in the High Court, in commercial divisions. And as you know, sir, Section 37 is an appellate remedy from any challenge that is rejected, and ultimately a 136 challenge is also available. So given, and you have on the one hand, you are trying to promote institutionalized arbitration, you put in 29A, you put in timelines, you want arbitrations to be completed in a year and a half. But when it comes to a challenge, because the mindset of the Indian litigant basically is that he will not pay. I mean, if he is an award debtor, his mindset is obviously to try and take advantage or recourse to provisions of challenge, provisions of appeal, and ultimately 136 if all else fails. Therefore, what happens is, when a challenge is made, because when you have state-appointed judges, first appeal, and look at the mindset of judges also. I'm not complaining, I'm not saying they're doing anything wrong. All that I'm saying is, when it comes to a first appeal from a money decree, the tendency of judges is, it's a first appeal, surely he must be given a right to say what he likes. One right of appeal is not harmful. The same mindset is going to prevail when it comes to a challenge to an award, where expressions like fundamental policy of Indian law and justice or morality are given a wide interpretation. So what happens is, the slightest door that is kept open for a challenge without restricting the scope of challenge encourages award debtors to take their chances, and for judges who are already burdened or overburdened, let's put it that way, with a huge backlog of cases, it becomes, in a sense, easier for them to admit a petition. Now, given the combined effect of Section 36...
No, we understand the point which you are making,
yes.
Mr. Dwarka. Actually, that brings back the point of that we need specialized judges. Let me tell you from my experience, even under Section 34, in Delhi High Court, some of us, when a petition is filed, we were seeing, even before issuing the notice, whether it comes within the four corners of section 34. And we would dismiss the petition there and then without even issuing the notice, because what's the use of issuing the notice? But then our division bench reversed us at that stage, saying the same thing. No, at least notice should be given to the other side. Justice Anloy is laughing, he knows what I am talking about. And but say it from other angle, what I feel is that ultimately when the case is decided, and if you see the record, maybe it has not been, there are no scientific studies made, the Indian judiciary has interfered minimally, not in many cases, maybe very gross cases where they have interfered. But what it had led to was delay. When the objections are to be heard like an appeal, as you rightly suggested, and then there will be full-fledged hearing, and that would consume time. Do you think, yes, that maybe if the mindset is changed and the amendment which is suggested, and that amendment is taken into consideration, and particularly the objective behind that, maybe that bring about a change in mindset. But at the same time, one amendment which is made in section 36 also may take care of, to some extent, what is your opinion as far as delays are concerned, because if no stay of, it is a decree now. Earlier the opinion of the Supreme Court was that the moment award is challenged under section 34, there is an automatic stay and the award cannot be enforced. But now it is almost brought at par with order 41 rule 5. Specifically, rather, it is written also there that it is going to at least at that stage deter the parties, because if there is no stay given and the money is either deposited in the court or even given to the other side, may at least eschew the frivolous kinds of objections, etc.
May I respond to that? In fact, I gave it a lot of thought, and I find actually that it will have the reverse effect. I'm sorry to sound a kind of a pessimist, but as a practicing lawyer, let me tell you at a practical level what happens in courts. When judges are burdened with work, they have to decipher between what is it that shocks the conscience. Now, expressions like this, which say that you apply the judicial conscience test, I mean, it is very difficult to say that every judge will have the same level of judicial conscience as the other, because that is one of the tests which is being applied to morality or justice. And such subjective tests, when they are to be applied, and the record is heavy, the case is complex. In fact, what judges will do, and we have seen it in practice, is that they will find the easy way out by saying, okay, now there is a power to grant a conditional stay. So the judge will think that he has done justice by making the judgment debtor deposit the amount in court or part of the amount, or ask him to give security, put him into the judicial queue, which may have a backlog of 5 or 7 or 10 years, and then the award holder is back into the system.
I think, Mr. Dwarkadas, there we won't agree with you. On this side. And Justice Chandrachud immediately prompted and said that no, he's wrong on this.
I hope I am.
No, I tell you.
I hope I am.
When the some obligation is imposed on the other side to deposit, etc., at least then that side would be there to pressurize the judge or say that.
May I answer that?
I think we should not enter into this debate. We don't have much time, and very important aspect we have to. But before that, within 2 minutes, if Shirin, you can say how in UK the approaches of the courts in enforcement of the awards.
Sure. Besides the grounds for challenge as the New York Convention, there are basically 2 grounds for challenge which are mandatory but very limited, again, for the UK courts. One is if the tribunal is found to have substantive jurisdiction. So that is in the sense, if there is found that there is no valid arbitration agreement, the tribunal was not validly constituted, or the matter was not subject to arbitration as per the arbitration agreement, then the court will either confirm the award, vary it, or set it aside. The second ground, which is a controversial one, which is the serious irregularities ground, which affects the tribunal, proceedings, and the award. But it's more about the process rather than the actual award. So the test really is, has there been a serious disadvantage that has been done? And has a tribunal gone so wrong in its conduct of the arbitration that justice calls out for it to be corrected? And it is very, very rare for these grounds of challenges to be upheld. One of the grounds, there are a number of grounds, but one of the grounds is public policy, and that is not defined under the English Arbitration Act. But it is very narrow, very restrictive, and the courts in England have extreme caution, and it's in extreme cases that they will say that it's against the public policy of England. So very, very rare.
So actually grounds are almost the same.
Yes.
It is again, we come back to mindset and how these grounds are to be taken
Absolutely.
and interpreted in a given situation
Yes.
by the courts. And
There's
when we are
also-
talking of these enforcement of international awards, Mr. Dattar, you tell us what do you think would be the or are going to be the practical difficulties in enforcing foreign awards in India, and what are your suggestions in reducing the hurdles?
Yes. Before that, with your permission, I just want to convey some good news. I mean, we've been talking of the gloomy scenario and so on, but the statistics are just the opposite. There's a wonderful article by Sumit Kachua in the Asian Journal of Arbitration, and I was pleasantly surprised to note that out of the Section 34s filed in various high courts, 79.5% have been dismissed.
That's what I
Then
said.
4% were modified, and 16.5% alone were allowed. As far as international awards are concerned, out of 17 reported judgments, only once has the court interfered with awards. So, as you put it, there's only a question of delay. So, basically, for a successful party, the path to judicial moksha is slightly delayed and slightly bumpy because of initial applications. Now, other thing I must also mention to the audience here, in the Nani Palkewal Arbitration Center in Chennai, which Mr. Nariman was inaugurated 10 years ago, the good news is that there's an increase of 30% per annum increase in arbitrations. We used to have 60 sittings in 2012, today we have 120 sittings per month. So the number of arbitrations are also increasing, which also calls for serious study of these provisions. Now coming to enforcement of foreign awards, I've spoken to my colleagues and basically there are three provisions. As Shireen and Justice Sikri rightly put it, the same Section 48 is in Singapore law, the same Section 48 is in UK law. After all, it's the unilateral model law, same law. It's just a question of implementing it. Now, the three difficulties which we find here, one is that call it a mindset, there's still a tendency to take it as at least as a part appeal and say that the award has been passed, let us at least hear what he has to say. So, there is a tendency to interfere. Second thing which I want, as you said, one suggestion I wanted to make was, if a person has got a Singapore award and he has challenged it in the Singapore Court of Appeal and the petition has been dismissed, then I think the court should be very, very reluctant not to enforce the award. Worst cases, a person doesn't choose to appeal in UK or in Singapore, yet he comes to India and then takes up Section 48 and goes on and on about public policy and so on and so forth. So that is the most important thing, is the judicial mindset, and to say that where that court has dismissed the petition, don't interfere except in the most egregious cases. And I may also mention another happy part is Michael Huang, who's a leading arbitrator from Singapore. He wrote an article and made a comparative study of all the Asian countries, Korea, China, Hong Kong, India, Pakistan, Indonesia, and so on. And he found that the main complaint about most people from abroad was that we interpret public policy too broadly and we tend to interfere into awards on grounds of we try to see what is the Indian law, what the Indian judge would have held, and then try to interfere. That is the thing. If you can avoid that, then I think
the statistics which you have given from Mr. Kuchwa's article and other articles, now if out of 17 awards, international, 16 are upheld, still international community thinks otherwise. Maybe one problem may be delay, but now my question to both.
One more thing, sir, since you mentioned about delay, what international community? One thing is non-implementation of 48 subsection 3 of the Act, because what happens is, once the award is against you and you prefer an appeal, generally Indian courts say that till that petition is decided, I will not listen to this enforcement. That's okay. But very, very rarely Indian courts make order for security. That pending that appeal gives some security, that's not done. So that again is a big worry, because suppose in the judicial queue it gets delayed by 3 years, what happens? You will ultimately end up with the paper award.
So Justice Chandrachud, you and Justice Ravindran, then I'll ask him also your last words. How to change this perception even when we are doing so well?
Well, I think
Let me begin by saying that, well, ONGC versus saw pipes has been regarded as the villain of the piece. I contributed to it because I was reversed by the Supreme Court in ONGC versus saw pipes. But I think the most important thing is that we send this message across that even during the period when ONGC versus saw pipes operated and governed the field of law, the approach of courts was really very different, because ONGC versus saw pipes was in that sense an aberration in the arbitration world. That's not the way commercial judges, whether in Delhi or Bombay or Madras, dealt with arbitration challenges. The predominant approach of a judge who is hearing an arbitration petition is, well, parties have trusted themselves to an arbitrator. I'm going to abide by that sense of trust unless the arbitrator has done something radically or drastically wrong. Now, Mr. Dwarkadas is right that when you have norms such as contrary to the fundamental policy of Indian law or something contrary to basic notions of morality and justice, these norms are open-ended. But tell me, how better can you frame a law than what you have done here? The point of the matter is that you have to sensitize, and not sensitize in the sense by training judges, but sensitize also the consumers of justice, that our judges are not trigger happy. Thank you, we are not trigger happy in the area of arbitration. We trust arbitrators. We trust the fact that parties have intended to attribute a sense of business efficacy to their contract. And one way of attributing business efficacy to the contract is that when it goes to court, you hold them down to their bargain, even if there is an error of judgment on the part of arbitrators. Because an error of judgment in arbitration is one of the business costs which parties factor in. It's not something which is, akin to a laborer losing a job or somebody losing an injunction suit in a trial court. Arbitration costs are part of your overall business expenditure. So you allow parties to settle with the norm of arbitration which they have adopted. So I think just as the Indian state, the actual state of the law in India was not radically changed by ONGC versus saw pipes, so also the deficiencies in drafting any piece of legislation on arbitration is not going to make it so much more easier to raise challenges to arbitral awards.
Would you like to add, Justice?
I would like to add, as far as challenges under 34 in high courts, where there is a process of admission, where somebody looks into it, whether it is a worthwhile case to take on. The problem is with states where it goes before the trial judges. For example, in Karnataka, a petition filed under section 34 is termed as a suit. And the minute, you call it as a suit, the mentality is written statement, issues, list of witnesses, evidence. It takes umpteen number of years. Why not our judicial academies, National Judicial Academy and the state judicial academies? They give training on how to conduct criminal cases, how to conduct family court cases. Why not a training on how to deal with 34, particularly cases under 34 and other related provisions in the Arbitration Act? That is one way of practically ensuring that our judges know. We do have a problem. Singapore does not have a problem because they have very few judges dealing with this matter. We have, as you rightly said, we have about 16 to 17,000 judges. And by the time we train one lot, they get retired and somebody else comes who does not know about it. Therefore, it is a constant fight. This can be dealt with only by having a judge dealing with it. For example, this also you mentioned, if you tell a Chief Justice of a state that, look here, you should ensure that in commercial jurisdiction or arbitration jurisdiction, you should have somebody who knows the law, he will say, you are trying to interfere with my freedom. It is my prerogative. Now, this mindset should change. The Chief Justice, you should have a conference of Chief Justices as to how to deal with arbitration.
How to set rosters.
How to set rosters also.
And continue with that, not to change it every second month or every fourth month or every 6 months.
2 months you are there and then somebody else comes in. And you see, every time somebody comes, he has to be taught. So these are things which can be dealt with by the judiciary itself, by a concerted effort of the Supreme Court.
So though we have run out of time, I'll ask the organizers, can we have 2 or 3 questions from the audience? I think nobody is here to check us, so we can go ahead.
Yeah, I have a question regarding the enforcement of foreign arbitral rewards.
Who is speaking, please, if you
I'm
can
Anand
stand.
Dayal.
Yes.
I'm Anand Dayal. I'm based here in Delhi. I'm a lawyer. My question is regarding the enforcement of foreign arbitral awards. And it's nice, I think, to pat ourselves on the back and talk about the nice statistics of 79% being enforced. But the reality, I think, tells a slightly different story. And my question is to Mr. Datar, if he would shed some light on the White Industries case, which was a case that involved a $40 million foreign arbitral award, an ICC award, that was not enforced for 10 years and resulted in a violation of the India...
So that comes in that 20%. Yes. Please, you have been asking question all. Yes.
Okay, may I otherwise just say, my name is...
You can use the other mic.
My name is Sarosh Zaiwala. I'm a practicing arbitrator, and I have a law firm in London for the last 35 years.
We know you, Sarosh.
Yes, but anyway, and I'm going to share my experience of having handled over 1,200 international arbitrations in London and in India. I was going to share that, as Fali Nariman said yesterday, at the end of the day, what matters is the common sense approach by the judges.
Yes.
In England, what happens is the judge feels and sniffs if something has gone wrong, and he decides. And I'll give you an example of a rare-ish case of public policy. That's the case of Indian Oil versus Coastal Bermuda, where there was an award of 18 million against Indian Oil, and the arbitrator, there were 3 eminent arbitrators, QCs, and Gordon Pollock QC wrote a postscript saying that if the Indian Oil's counsel team, Indian Oil's legal team was better, the result might well have been different. This is a reported judgment. The question is then, there was no challenge. So we applied to set aside, I was not acting for, we applied to set aside on the grounds of public policy that the English court has to enforce the judgment, awarding to judgment, which will not be based on the true legal analysis. And Mr. Justice Evans said, having looked at everything, that speed is good, but justice is better.
Yes.
May I also very quickly share my experience on the commercial bar? Now, you can't specifically have an arbitration bar. It has to grow by reputation. Now, England, the commercial bar normally has arbitration counsel like Essex Court Chambers, Big Court Chambers. Sharina is right, there is construction chambers, but it goes by experience. That is not very right. Now, whether the arbitrators, breach of arbitrators order can be contempt, the answer must be no. Because contempt is a very serious jurisdiction, which only the judge with his experience can have it. But there is a provision in the English Arbitration Act where a party can apply to the court to convert the arbitration order to the court order, and thereby the court enforces the order, and that is something to consider. Now, challenges to the arbitration award are rare. One of the grounds is bias, but there's a test of bias, which is the average common man. And what we really require now...
No, but we don't have that much time for you.
Can I just mention the perception? Can I just
Yes.
mention the perception? Because every international congress, wherever we go, there's a complaint that Indian arbitration is bad. We have to make sure of integrity, and that can only come from internal self-regulation, and that is very important.
Thank you.
Sir, I have a question. Here, sir.
Just
Sir.
yes, sir.
Yes.
Here a question. Now, the judiciary in India, sir,
Yes.
the judiciary in India, do you think that...
You are also asking too many questions.
Only one question I asked in the morning, if you...
Yes.
It's the perception. That is exactly what I was trying to say. Don't you think that we require introspection in the behavior of judges, of our courts, so that international community will have some more faith in Indian arbitration
that is the
process?
message which is given. What I feel is, yes, much is said about mindset, about the training to the judges also, but I'm realizing one thing, when we have training of judges in Judicial Academy, it should not be the trainers or the resource person should not only be the judges. We should have other stakeholders also, so that they give their viewpoint, which may bring about, I think, better change in the mindset. Thank you very much. I think that's what
Thank you very much, Justice Sikri and respected panelists, members of the audience. We move on to our next session that deals with an outsider's perspective of arbitrations in India. We'll quickly make the changes up on the dais.